The O'Keefe family has now filed a civil lawsuit against Karen Reed. And this is very common in a lot of murder cases. You'll have the criminal case, and then you'll also have this civil case. And the first thing that you have to understand is that it's very different. Civil arena, the civil courts are very different than the criminal courts. And the main distinction, the main difference between a civil case and a criminal case is the fact that the burden is less in the civil case. So we know in a criminal case, the prosecutor has to prove their case beyond a reasonable doubt, which is an extremely high burden, because we're going to impose a criminal penalty on somebody, then we have to really make sure that the prosecution is really doing their job and the evidence is really, really strong. So then we're going to make them prove their case beyond a reasonable doubt. When it comes to money damages, someone's going to be out a few bucks, so we don't care as much, and therefore we say it just has to be more likely than not that the plaintiff is actually saying the truth. So if you have got the evidence on the plaintiff's side and all the evidence stacked up on the plaintiff's side makes the jury believe a little bit more that the plaintiff's story is true than and the defendant's story is not true, then you go with the plaintiff. That's more likely than not. That's what we call the preponderance of the evidence. So the burden's less in a civil case. So a lot of times you can have a case where in the criminal court, the person was acquitted, 100% found not guilty. But in the civil case, they will be found to be liable for money damages. So the O'Keefe family felt that now is the time to sue Karen Reed in civil court. And this is also before the criminal case the second criminal case is going to be tried, right? The second retrial of Karen Reed is supposed to happen in January. So they didn't want to wait, and they filed this right away before the criminal trial is supposed to happen. Now, whether it actually happens or not, we don't know 100% yet after Trooper Proctor is gone. And I mean, it's going to be a little bit more of a different trial, but still, Commonwealth's position is that they're going to retry this case. So this civil case comes first. So that's the first important difference, that there's a difference between the preponderance of the evidence and the difference between beyond a reasonable doubt. But there is something that really stuck out to me in this complaint. All right. One of the things that stuck out to me in the complaint, and we're not going to be reading every single paragraph of this complaint. If you want to get a full reading, I'm sure there's a lot of other channels that will just simply read for you the entire complaint. That's what we're going to be doing today. We're going to be just analyzing this complaint, explaining the causes of action, and seeing whether there's any merit into this complaint at all. So one thing that stuck out to me, which was glaring, is that I counted at least 6 times in this complaint where it is alleged that Karen Reed was negligent, that she was negligent in hitting John O'Keefe with her car. Now, that's a very important word, negligent, because we know that she's being charged with second-degree murder in the criminal court. Now, second-degree murder requires intent. Negligence is not intent. Intent is intent. You intentionally hit someone with the car, then you're liable for second-degree murder. So in the criminal case, they're arguing that she intentionally hit him with the car. Nevertheless, in the civil case, it's alleged in a number of different paragraphs that she acted in negligence. So why would they do that? Why would the O'Keefe family, why would this attorney who's representing the O'Keefe family say negligence? Well, number one, it's a little bit easier to prove. Number two is that when you are negligent, it's more likely that the insurance company is going to cover you. If you intentionally hit someone with your car, your insurance company is not going to cover you. If you negligently hit someone with your car, then your insurance company will cover you. So in terms of getting the insurance money, which is what everybody wants, the insurance company's not going to run out of money. So you have to allege negligence. But here's where it gets interesting, because now we have this new trial coming up, the second trial coming up in January, the criminal trial. Now, this complaint was already filed, so the civil trial is not going to happen for a long time. But the criminal trial is happening in January. Officially, maybe it gets pushed off a month or two, but it's going to be happening much, much before the civil case. Nevertheless, we have the complaint that's already filed. So if I'm the defense attorney, if I'm on Alan Jackson's team or David Yanetti's team, if I'm on that team, then now that I have this complaint, this opens up a whole new avenue of cross-examination. When Paul O'Keefe is now on the stand, so now this is a very reasonable line of cross-examination. It goes the following. Mr. O'Keefe, isn't it your position that Karen Reed did not intend on hitting John O'Keefe? Isn't that your position? And he either may say yes or no. Now, whatever he says, here's how it goes. No, my position is, let's say he says, no, my position is that she intended to kill John O'Keefe. She intended to hit him with the car. Well, if that's true, you filed a civil lawsuit in this case, didn't you? The answer is going to be yes. Now, again, maybe Judge Cannone will keep this out, but I think that this is fair game. This should be fair game and should be argued by the defense attorney. They should file a motion right now to allow them to impeach evidence, impeach the testimony with this complaint. And a lot of times it's allowed in. So this is how it would go. Mr. O'Keefe, your position is that she did not intend to kill John O'Keefe. Oh, no. My position is that she did intend to kill John O'Keefe. Well, you filed a civil lawsuit in this case, didn't you? Yes. And in that civil lawsuit, you said that Karen Reed was negligent, not that she intended to hit John O'Keefe. Wasn't that your position in the lawsuit? Well, I don't remember. Okay, here, take a look at it. Paragraph, whatever it is. In that paragraph, it says clearly, Karen Reed was negligent. Is your position now, in front of this jury, you tell the jury, is your position that she intentionally killed John O'Keefe, or is your position that she negligently killed John O'Keefe? Which one is it? And now there's no right answer. He's going to really be stuck, because if he says, no, she intentionally did it, well, then you lied to the court in your complaint, didn't you? Why did your attorney lie for you? Did he show you this before he filed it? Didn't he meet with you and talk to you about what the evidence is and what the facts are in that case before he just filed something in your case? So that would be, I think, a great line of cross-examination. And the minute that if he says, well, yeah, maybe she was negligent. Oh, she was negligent? So then your position is that she's not guilty of second-degree murder, isn't it? Because second-degree murder requires intent. And your position here is that she did not intentionally kill them. Your position is that she just was negligent. And therefore, second-degree murder should be off the table in your opinion, isn't it? Now, of course, you can't go exactly with this line because he'd be giving an ultimate opinion, whatever. You get the gist of what I'm doing here. This is how it would come out in cross-examination. And now I think that they filed this paper. This absolutely has got to be on their cross-examination right now. We'll see. We'll see if they actually take my advice on this. But absolutely, this is something that I would do if I was the defense attorney. All right, so that's number one. Let's get into the different causes of action that are alleged in the complaint. And then I'm going to give you my opinion ultimately at the end, whether the plaintiff can actually prove their case by the preponderance of the evidence, which again, it's a lower burden. Can the plaintiffs prove their case with all the arguments that we've heard Lally say over the course of this trial, that there's some taillight that was embedded in some of John O'Keefe's clothing and everyone in the house testified that he never came in, all that good stuff. So we'll see whether, in my opinion, that actually rises to beyond be a preponderance of the evidence. All right, but let's first talk about the different causes of action. So the first cause of action is something called a wrongful death. Wrongful death is many jurisdictions have a wrongful death statute, and in Massachusetts is no different. And this is where someone dies, and if the person was alive, he'd be able to have a lawsuit for the reason that he died. So again, in this case, it would be a car accident. And then what happens is the following. You are allowed to collect, as this person already died, but the survivors, family members, are allowed to collect certain damages. And this is what they're allowed to collect. Number one, the fair monetary value of the decedent to the persons entitled to receive the damages recovered as provided in Section 1, meaning certain family members, including but not limited to compensation for the loss of the reasonably expected net income. So what net income would John O'Keefe have made if he would have still been alive? Services, what type of services can he provide to his family? Protection, care, assistance, society, companionship, comfort, guidance, counsel, and advice of the decedent to the persons entitled to the damages recovered. So his children, right? They need his advice. They need his counsel as they're going through life. They're going to be missing that. What type of money damages can we award for that? That's number one. Number two, reasonable funeral and burial expenses of the decedent. Number three, punitive damages. This is an interesting part. Punitive damages. And this is something that they absolutely allege in their complaint. Sometimes you are allowed to collect punitive damages. A lot of times you're not allowed to. Punitive damages means that we are going to punish you. These are not damages that equal a certain loss that you sustained. These are damages that are going to be used to punish you for your action. So a lot of times you're not able to collect punitive damages. Sometimes you are. And this is one of the examples where you are allowed to collect punitive damages. And here we go. Punitive damages in an amount of not less than $5,000 in such case as the decedent's death was caused by the malicious, willful, wanton, or reckless conduct of the defendant or by the gross negligence of the defendant. So if a jury finds in the civil case that Karen Reed was grossly negligent, she was willful, wanton, or reckless in her conduct, then they can award punitive damages to punish Karen Reed. All right, so that's the wrongful death statute. Now there's another cause of action, which is called dram shop. Dram shop is very simple law. The law is that if you are an establishment that sells alcohol, you are not allowed to sell alcohol to, number one, a minor, and number two, anyone who is visibly intoxicated. If someone is intoxicated, you are not allowed to sell that person any more alcohol. Pretty simple. Now, if you do, and that person goes and hurts someone as a result of him being intoxicated. So, for example, very classical case is if the guy gets in his car now and drives down the highway and smashes into a bunch of people, and it's because you kept serving him more and more and more drinks, even though he was intoxicated, then they can have a dram shop action against the establishment for serving them an abusive amount of alcohol. So this is the argument against C.F. McCarthy's and the Waterfall. Now, what everyone is probably wondering is the following. We have had a number of witnesses already testify in the criminal trial that Karen Reed was not showing any signs of intoxication at all. There was no visible signs of intoxication. Everyone testified she wasn't slurring her words. She wasn't stumbling over herself. She wasn't overly loud, or she wasn't acting overly intoxicated. Well, then that should put the end to the dram shop action. There should be absolutely no basis for this dram shop to bring in C.F. McCarthy's and Waterfall into this case. But it's not actually that simple. You're right. That's a great argument, but it's not dispositive. Dispositive means that doesn't finish the argument and finish that you're done. It's not dispositive. Why? Because there's an interesting part of the law in Massachusetts. Okay? You do a little bit of research. That's what we do on this channel. We do a little bit more digging than some of the other channels. And there's actually some more research here. And what the case law in Massachusetts says is the following. That even if the person is not exhibiting signs of intoxication, but the bartender knows that that person has already had a number of very, very alcoholic-filled beverages, strong alcoholic drinks. And this is the exact quote from one of the cases in Massachusetts. It's Camino versus Milford Keg. And in this case, it says the following, that the service of large number of strong alcoholic drinks deemed sufficient to put the defendant on notice that it was serving a man who could potentially endanger others. So it's not just if a person is visibly intoxicated, but if the bar knows, hey, this person is on their 25th drink, I should probably not serve him again. That also would implicate the dram shop action. So here, the argument's going to be that we have this evidence. Some people say it's decent evidence. Some people say it's not such clear evidence. But the argument's going to be that C.F. McCarthy's and the Waterfall knew that she was having a lot of drinks. She had a number of drinks, and they kept serving her more drinks. So is the number of drinks that she had, 7 or 8 or 9, whatever you want to argue about it, is that number of drinks for a woman like her, should that already put the defendant on notice that I am serving an intoxicated individual? And again, that's going to be where the argument is. All right. So I just want to let everyone know that this issue of everyone testifying that she was not visibly intoxicated is not dispositive alone. It doesn't put the issue to bed alone just by that, because there's also this other argument of if they served her so many drinks, then they should know that we should probably stop serving her that many drinks. All right. So that's just the argument. I'm not saying it's persuasive. I'm not saying it's the greatest argument. And it's not like she was served 25 drinks and that they were all hard alcohol. I'm not saying that, but this is the argument, which is maybe can get them past a summary disposition motion. All right, let's move on. Then there is something called negligent infliction of emotional distress. And this is a very controversial cause of action because there's a number of jurisdictions that don't even recognize this cause of action, negligent infliction of emotional distress. Many jurisdictions you can't even sue under that. So in Massachusetts, you could sue under that. And this is what happened in Massachusetts. There's a number of different ways to analyze negligent infliction of emotional distress. And that is for the following. The basic idea is if I commit a certain act on an individual, let's call him person A. If I commit a certain act on person A and person B is right there, and let's just say for simplicity, person B is related to person A, and they see me right in front of them, and I go and I do something terrible to person A, and person B is right there seeing it. And now that person B has emotional trauma because of that, and they can't sleep, and they have nightmares, and they have problems. So can person B now sue me, even though I never did anything directly to person B? I just did something to person A. Is that enough? So that is where negligent infliction of emotional distress comes in. And there's a number of different ways to analyze it. Jurisdictions go haywire over this, and it can get a little complicated, but everything on this channel is simple. So this is one of the ways that Massachusetts analyzed it, and I'm going to explain how they came off of a certain way and they moved to a different way. So there's something called the impact rule. The impact rule means that there has to have been some sort of direct bodily injury that you suffered. So it's not enough for you to just watch. There has to be some sort of impact between myself and you. Just you watching is not alone. So that used to be the law in Massachusetts, but Massachusetts actually abandoned that rule. And they moved to a variety of two different rules. One of them is called the zone of danger rule. The zone of danger rule means you are in the zone of danger. So you're right next to person A. You're person B. You are person B. And you're standing next to person A. And person A gets shot in the head by someone. And you're standing right next to that person. That's called the zone of danger. You are in the zone of danger. Okay? If you're in the zone of danger, you can clearly, under Massachusetts law, have a negligent infliction of emotional distress cause of action. And of course, there's some other elements, but that's essentially basically how the cause of action occurs. Now, in this case, there is no zone of danger. I mean, the argument here is who is within the zone of danger but John O'Keefe? None. Okay, so there has to be another area where you can sue for negligent infliction of emotional distress. And that's what we call in Massachusetts the bystander recovery doctrine. The bystander recovery doctrine is the following. That is, even if you are not actually in the zone of danger, but if later you came to learn about it in a very direct way and you're related, so then that can also, and you have, obviously you suffer certain types of damages, then that can also implicate the negligent infliction of emotional distress. So in this case, for example, the case law is pretty clear that, and this is a case called Ferreter versus Daniel O'Connell Sons. In this case, the courts of Massachusetts said that if it's closely on the heels of the accident, if a plaintiff experienced shock on seeing the injured loved one closely on the heels of the accident, then they can also maintain an action for negligent infliction of emotional distress. So in this case, the argument by the O'Keefe family is that since pretty soon after this accident with John O'Keefe, they saw him in the hospital. They came to the hospital. They saw him in that state. And that caused them to have all this tremendous emotional grief and shock and damage. So that is close enough to the accident where they can fall under the bystander recovery doctrine, which is recognized in Massachusetts. Now, there's some other elements which include the following. Number one, negligence. Okay, that magic word again, negligence. So the person has to have acted in negligent. Number two, there has to be emotional distress. Number three, causation. It has to be caused by them seeing this, their family member, in this case would be Paul and Margaret O'Keefe, seeing John like that. And that was what the doctors have to say is causing them emotional distress. Number four, this is an important one. The physical harm, there has to be physical harm manifested by objective symptomatology. So it has to be that not, I just have so much anxiety, I'm just scared. There has to be some sort of physical harm which has objective symptomatology. All right, so that's also an important prong. And number five, that a reasonable person would have suffered emotional distress under the circumstances of the case. So the case law has said in Massachusetts the following, that you have to do more than just allege that you're upset, that you're dismayed, that you have humiliation, that you're grieving because you lost a family member like this, or that you're angry. It has to be more significant than that. There has to be much more physical harm that you have, like nightmares, loss of sleep, things like that, which can be objectively documented. All right, so that is another cause of action, negligent infliction of emotional distress. Then they get onto something called intentional infliction of emotional distress. Now, what are the elements of intentional infliction of emotional distress? This is the following. And this is under the case called Pillay versus McMahon. Number one, that the defendant intended, knew, or should have known that his conduct would cause, or in this case, Karen Reed's conduct would cause emotional distress. That's number one. So you had to have intended, you had to have known that your conduct is going to cause emotional distress. Number two, that the conduct was extreme and outrageous. And we're going to explain this prong because this is really important. Your conduct has to be extreme and outrageous. Number three, that the conduct caused emotional distress. And number four, that the emotional distress was severe. It has to be severe emotional distress. All right, well, what is conduct that is extreme and outrageous? And what type of conduct did Karen Reed perform that was extreme and outrageous? Well, this is what they're going to argue. But first, you have to understand what the case law is. So let's just finish off with the law, and then we'll see whether what they're arguing is going to apply for intentional infliction of emotional distress. And this is taken right out of the case. Tetrault, this is, again, Polly versus McMahon. Liability cannot be predicated on mere insults, indignities, threats, annoyances, petty oppressions, or other trivialities. Nor even is it enough. Listen to this. It's not enough that the defendant has acted with an intent which is torturous or even criminal. So if a person acts with intent which is tortuous, or even criminal, he has a criminal intent, this person, that's not enough. Or that he has intended to inflict emotional distress, or even that his conduct has been characterized by malice. Even if people would say, well, the way that you acted was malice, that was malicious in the way that you acted, that's not enough to be extreme and outrageous. So what is it? Listen what it is. It qualifies as extreme and outrageous only if it goes beyond all possible bounds of decency and is regarded as atrocious and utterly intolerable in a civilized community. That's how crazy the action has to be in order for it to be extreme and outrageous. Now, what are they arguing that Karen Reed did that was so extreme and outrageous? You ready for this? Here it is. In the complaint, this is what they say. This is not me making, this is what they say in the complaint. That it was outrageous. You know why? Because she created a false narrative. Again, according to them, she created this false narrative that she was all framed and she was set up and that she never even hit John O'Keefe, and this is all just one big frame job. So creating that false narrative, they're going to argue with a straight face to the court that that conduct was extreme and outrageous, so much that it's beyond all possible bounds of decency. It's worse than criminal intent by her making up a story, again, in their minds. And you know what else they're arguing is so outrageous, such extreme and outrageous behavior? The fact that she woke up Kaylee at 5 o'clock in the morning when John O'Keefe wasn't home, because again, and according to them, this was all part of the plan, that she woke up Kaylee and was hysterical and asking about where her father is. So that conduct, they're going to argue, was also extreme and outrageous. Now, there's something called, okay, that's it. Those are all the causes of action. Now, there's something called a 12b6 motion. And this is also in Massachusetts. It's not just federal. Federal, there's also 12b6. But in Massachusetts, rules of civil procedure, there's 12b6. 12b6 means that there's a failure to state a claim, which means there's different ways that you can ask the court to dismiss a case. Number one is that if after all the discovery has been done, you can move for a summary disposition motion, meaning that there's no question of material fact. There's no fact question that needs to go to the jury after the discovery. We discovered everything. We know the answers to all the questions. The jury doesn't need, there's no question left for the jury. Okay, that's after discovery is done. But there's something else, and that is if the plaintiff fails to cite a recognizable cause of action. This is called 12v6. And this is in Massachusetts law. If a plaintiff files a complaint, and in that complaint itself, even if we were to accept, forget about discovery, let's accept everything that the plaintiff said in their complaint. If still what they said in the complaint does not equal a cause of action, that's where I can file this motion to dismiss this part of the complaint. And if I was the defense defending Karen Reed in this civil lawsuit, the first thing that I would do is file a 12b6 motion. I wouldn't even answer some of this complaint. The intentional infliction of emotional distress, that fails. It's clear in the law that what she did, her conduct, maybe you'll say that even if we would agree that she lied, and this is all a fabrication, and this is all just one big act, still her conduct is clear under the case law that does not equal extreme and outrageous. So if I was the defense, I would right away move 12b6 motion to strike the intentional infliction of emotional distress part of this complaint. Now, the other parts of the complaint, there could be an argument for. There could be an argument for the dram shop, like I explained. There could be an argument for the wrongful death. Again, if we assume the way that 12b6 motion works, that you have to assume that everything that the plaintiff is saying is true, which means that Karen Reed actually did hit him with the car. Forget about whether there's evidence to that or not. You have to take the plaintiff's word at it as true for a 12b6 motion. And therefore, you would say that if everything they're saying is true, then yeah, there would be a wrongful death claim here, and there'd also be a dram shop, arguably, like we spoke about, and arguably there can be a negligent infliction of emotional distress if the O'Keeffes can actually show that there is objective symptomatology for their complaints of emotional distress. So you can say we need discovery to figure that all out. We need to see medical records. We need to see things like that. So I think that in order to get in the door, they got in the door with the wrongful death. They got in the door with the dram shot. They got in the door with the NIED. But the IIED, I'm sorry. I think that fails. And I think that should be the first move by the defense. If you're representing Karen Reed for the defense of this case, of the civil case, right away, 12b6, the IED part, and now you're just left with the other three. Now, ultimately, do I think that the plaintiff has a chance here to show that since the burden is much lower, it's just preponderance of the evidence. You just have to prove more likely than not that Karen Reed hit John O'Keefe with the car. And come on, we've all heard Lally's arguments. We've all heard those arguments that, you know, there's some DNA, there's some of the taillight that's embedded in his clothing, and you know all the arguments that we've heard from Lally already. So, is that enough to reach preponderance of the evidence? And this is my take as a trial lawyer who tries cases. And yes, try civil cases too. Okay, so I try plenty of civil cases. And usually I'm the plaintiff. Okay, so I'm usually representing the plaintiff in a civil case. And I'm suing an insurance company or suing an actor who did something wrong to my client. So that's when we go to trial, that's my position is usually the plaintiff's position. Okay, now if I had this case in front of me, and as a plaintiff attorney, I had all the facts as Lally. I've got all the evidence that Lally is ready, that we've seen in the criminal case. And the defense has nothing except these two expert witnesses. These two expert witnesses, biomechanical engineers, who work for the federal government. They were hired by the FBI and the DOJ. They weren't even hired by the defense attorney. And every single case, almost every single case, you never have an expert who wasn't hired by one side. They're always hired by the side. The plaintiffs have their experts and the defense has their experts. And you both hire them and you have to pay them good money. But do they ever come in? Did they ever perform some sort of analysis objectively because they were hired by a third party? Never. Well, in this case, there's actually two extremely qualified experts who were hired by an independent party. They're completely objective. And they're going to say in the trial, they're going to be called. Definitely. They'd be the first two witnesses on my witness list. And I don't know if I'd list anybody else if I was the defense. These two witnesses. And they're going to say that it's just inconsistent. It's inconsistent. There's no scientific explanation to how the injuries occurred on John O'Keefe's arm and the damage to the vehicle. There's no scientific explanation of how this this event occurred as the plaintiff is trying to allege. There's no scientific explanation. What is the plaintiff going to argue back? Were they going to call Trooper Paul? Trooper Paul with his 6-week course that he took as a Massachusetts state police officer? Now, I'm not trying to put down Trooper Paul. I'm sure he's a great state cop. And he probably took a course that was probably hard for a lot of other cops to get into, and he did well. But that doesn't put him in the same ballpark as these two extremely highly qualified experts who are completely independent and objective. So if the plaintiffs in the civil case cannot hire real expert witnesses on the same level as these other biomechanical engineers who have testified clearly that there's just no scientific way to explain how this all happened, the way that the plaintiff is trying to argue it, the way that Lally is trying to argue it, there's no scientific explanation for that, then I will take the defense all day in this case, even on a preponderance of the evidence standard. Now, if the plaintiff attorneys go actually hire real experts, then you may have a chance on winning. But again, if I'm an attorney and I'm looking at this case and I've got this case in front of my desk, I don't care if it's preponderance of the evidence. I still have a problem. How am I going to argue? How am I going to rebut those two experts? So that's what I think. I think as it stands now, I think even in a preponderance of the evidence standard, I still think that Karen Reed should still win even in civil court. That's just the way it seems to me as an attorney, as a person who tries these cases, these type of cases. So again, if the plaintiff attorneys go hire real experts, they have a shot. Same thing, by the way, in the criminal case. If Lally actually hires real expert witnesses, then he has a shot. Again, they're not going to be as objective, but he has a shot of winning. But until there's other real qualified experts who can rebut these two experts that were hired by the federal government, who are extremely qualified, there's just no winning this case, whether it's in the criminal case or whether it's in the civil case. Now, again, juries can do anything. So I can't tell you that you're not going to convince a jury to do this, because juries may do anything. You can't, you don't know for sure what juries are going to do. I've seen juries do a lot of crazy things, which to me didn't add up. But as a lawyer looking at this, it's hard to imagine how they would win when you have these two experts on Karen Reed's side. So that is my analysis on the complaint. Please, if you haven't, let's subscribe, like, and we will see you next time.